YouTube, what's going on? Attorney Darling here, and I'm back answering another question for you. Today's question is, if you or a loved one are arrested, will you get bond? And then we'll answer, well, what's a bond? And does an attorney help with that? So the first question of that is, really we have to start at the beginning. What the heck is a bond? Sometimes called bail. So oftentimes these terms are used interchangeably. They're a little bit different. Bail is when the defendant actually posts a certain monetary amount to be released. Bond is usually posted by a family member, a loved one, and it's usually done through what's called a bail bond agency. If you go to pretty much any jail, anywhere, but specifically in Florida, usually across the street, around the corner, there are multiple bail bond agencies, and those agencies generally charge 10% with a minimum amount of $100. So what that means really is, if you end up with a $500 bond, you don't get to pay $50. The bail bonds got to make a little bit of money, I guess, and they charge initially about $100. So will you get bond? Will you get bail? These are incredibly important questions. In the state of Florida, I'm going to read to you really quick a rule of criminal procedure that talks about bail bonds. It talks about pretrial release, which is what all of this is about. So if you're trying to get a bail, if you're trying to get a bond, generally this is pre-trial, right? I mean, every time, not every time, but most times it's pre-trial. There are some limited circumstances where after a trial you may be granted a bond in order to, appeal or fight sentencing, something of that nature. But generally, Florida Rules of Criminal Procedure 3.131 is the right to pretrial release. Okay, so in the state of Florida, unless charged with a capital offense or an offense punishable by life imprisonment, and the proof of guilt is evident or the presumption is great, every person charged with a crime or violation of municipal or county ordinance shall be entitled to pretrial release on reasonable conditions. So reasonable conditions don't mean for free, right? We wish it did, but it just doesn't. Reasonable conditions mean you could be placed on ROR, which is released on your own recognizance, PTR, which is pretrial release, which has some conditions regarding checking in. Sometimes it's via phone, sometimes it's in person. With a person who is essentially a probation officer, but you are not on probation, you're just checking in. Those are conditions of your pretrial release. Well, when do you find out if you're going to get a bond? So you or a loved one have been arrested. When do you find out if you're going to get a bond? Generally, there are two times you're going to find out. First is if the particular county that you are arrested in has what's called a bond schedule. A bond schedule is a standard amount of bond based on the charge that you are facing. So for example, if you get a battery charge, the standard bond may be $500, okay? Which means, of course, if you pay it a cash bond, which is the full amount, you pay the $500 after the case is over. That either goes towards court costs, court fees, or when you win, it all comes back to you. If you just post the 10%, which is in this case $50, but like we talked about briefly, it's going to be $100 basically to have somebody post it for you. They keep the money pretty much regardless of the outcome. So that's the first way it's said, is by schedule. And everything from the smallest municipal ordinance, petty theft, has usually a dollar amount. Some of the more insignificant crimes, like if you don't have a history at all, but this is even before they evaluate that. So some of the most simple crimes, a municipal ordinance violation, may very well be released on your own recognizance. And then you just show up, you get a notice to appear, you show up on that date for that charge. As you start to go up from misdemeanors to felonies, you may go from a $200 bond, a $500 bond, up to $1,000. As you get higher up, like the Florida Rules of Criminal Procedure talk about, as long as it's not a capital offense, or a PBL, or punishable by life offense, you're pretty much entitled to a bond. That doesn't mean you can afford it, okay? It means that you're entitled to it. So eventually, getting up into the third-degree felonies, aggravated battery, battery on a law enforcement officer, things of that nature, you are going to have to post a bond, okay? There's an automatic schedule for it. And if you feel like it's too high, if it's unreasonable, if the facts of your case just don't justify that amount of bond, there is a way to get that bond reduced, okay? And normally that happens at first appearance or by an attorney filing a bond motion later on in the proceedings. So if you may have an offense that just doesn't allow you to get bond without going to first appearance. Generally, domestic violence cases have this requirement where you don't get to just go in, pay your $500 if it's a battery, and get out. You actually have to go in, get in front of a judge the next morning usually, and then the judge will decide whether to grant you bond. The bond amount is going to reflect the seriousness of the charge. So the other way you get bond, other than the bond schedule, like I mentioned, is first appearance. So you come in the morning, essentially after you're booked, and you get in front of a judge. That judge will determine whether there was probable cause to arrest you, probable cause to hold you, and at that point, they will decide what your bond amount is. So does an attorney help with this? It depends, right? And I know that's sort of a common legal answer, right? It depends. Does an attorney help? Maybe. So the process itself, always reach out to an attorney as quickly in the process as you can, okay? That's so important. So if you have a friend or a loved one, or you were arrested, you definitely want to reach out to an attorney right away. You want to do that because if you get a bond schedule amount that you are unable to pay, there may be some what are called mitigating factors to determine at a hearing in front of a judge, in front of the state, that bond may not be appropriate for you. So, all right, so the judge needs to consider all of the following things: the nature and circumstances of the offense charged, the weight of the evidence, the defendant's family ties, length of residence in the community, employment history, financial resources, mental condition, past and present conduct, essentially saying, has this person showed up to court before, nature and possibility of danger, if they're released, and it's danger to the community. Okay, it's not necessarily danger to a specific person. They want to talk about the bail funds, bond funds, where are they getting this money? Are they getting the money as a result of criminal activity? If the person is already pending resolution of another criminal proceeding. This is a case that oftentimes really hurts clients. So say you had a charge that you were arrested for, let's say driving with a suspended license. You're already out on bond for that. And you end up getting arrested again for petty theft, for maybe another driving with a suspended license, for battery, for domestic violence, for a domestic violence battery. All these different things. You go in and they're like, okay, here's bond on the new case, but we're revoking your bond on the prior case. Because realistically, if you are in jail and you're not out fighting your charge, you are much more likely to plead to something you didn't do. That's just a reality of the system. And then when it comes to does an attorney help with that, the other thing that I would say is when you're first given a bond, okay, whether it's through the bond schedule or a first appearance, oftentimes clients just can't make that amount. And that's the reality of today. If you're given a $5,000 bond, some people just don't have $500 laying around for a bond and more money to hire an attorney. So sometimes what families will do is they will hire an attorney and then have the attorney file what's called a bond motion. It's basically a motion to reduce bond, a motion to set reasonable conditions of bond. There's a bunch of different ways to sort of title the motion. And the way that we do that is we file a motion basically saying this person has these 10 things that are benefiting them. They're a member of the community, they're from here, they've never missed an appearance. Can you please reduce the bond? And generally that actually goes to the trial judge or the judge who's going to have that case normally, whereas first appearance, those judges generally are not necessarily going to have that case, or they're judges that only stay at the jail and essentially do pretrial hearings. So that's pretty much it for bail and bond. If you or a loved one are arrested, are you going to get bond? Most likely, right? That's the plan, especially in the state of Florida, only in the state of Florida. It's the only place I'm an attorney. So that's the only place I can tell you about that. And then does an attorney help with that? Normally, when it comes to the bond portion of it, if you get to an attorney early enough, if you or a loved one get to an attorney early enough, they can show up at first appearance. I've shown up at several first appearances, and you argue for a reduced bond. Does it necessarily help? No, but you do everything that you can. Oftentimes, the judges that are at the jail or just the initial appearance judges are going to be ultra conservative with letting somebody out on a small bond or no bond, just because they're not going to be the ones that have that case the whole time. So they really want to let the trial court judge make that decision themselves. All right, so that's pretty much it. Will you get bond? What is a bond? And does an attorney help with that? That's the question that we answered today. Guys, remember, I am Attorney Darling. Just because you watch this video does not mean we have an attorney-client relationship. If you have a question that you'd like to have answered on this YouTube channel, go ahead and send me an email, at attorneydarling.com. If you'd like to reach out to me, if you need legal services, if you need representation, definitely go to my website, www.andrewdarlinglaw.com. Reach out to me as soon as you can. Obviously, the sooner in the process you get it, get an attorney, the better. Thank you guys so much. I appreciate your time. I appreciate your support. Definitely hit subscribe. Definitely hit the like button on this video if it was helpful for you. I appreciate it. My goal is to be a resource to my community. That's my goal, is to put out these videos to answer questions that folks have that are not always easily answered in a Google search. So again, if you don't know an attorney, you're just a click away from one. That's me. I'm Attorney Darling. Thank you guys so much for your time. I appreciate it, and I look forward to working with you. Take care.